Okay, at this time, I'd like to call the meeting to order. If we can please take roll.
Chairman Delosier.
Here.
Representative Shemmel. Representative Hershey.
Here.
Representative Knoll.
Here.
Representative Davis, sorry.
Here.
Representative Lee.
Can't figure out how to work that thing. Okay, if we can, we're just announcing that the meeting is being recorded, so everybody is aware of that fact. Also, if we can silence all cell phones at this time so that we can be respectful of the speakers. And if we can, please stand and do the pledge, and then we'll get the meeting started. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, thank you. So we are here today, the House Judiciary Subcommittee on Family Law and the public hearing on House Bill 1397. Which is Representative Sue Helm's bill. So we'll be having a lot of testimony on that, and I know Representative Helm has comments. Also like to introduce my co-chair here with, I'm in the Senate today, I guess, in our House member, Representative Davis. Do you have any comments you'd like to share?
Not at this time, thank you.
And we also, as we have both our chairmen are here from the Judiciary Committee, so that is to be supportive of the bill and to hear the comments that we have. I'd also like to comment that we do have a very tight agenda, so those that are speaking, any summary that you can do, we do have all the testimony in front of us, word for word. So the comments that you make allows more time for questions, so the ability for us to get to the heart of the matter and the points that you guys want to make. We appreciate submitting all the testimony. We not only have testimony for those that are testifying here today, but also a fair amount of testimony that has been sent to the members of people that are concerned about the issue outside of those that we were able to have in today. We have, so the agenda is packed. So with that, we will introduce the prime sponsor of the bill, Representative Sue Helm. Come forward and make comments on your legislation.
Good morning, and what a great group of people here this morning. I'm just thrilled when I walked in this room and saw everyone here. But I would like to thank the Judiciary Chairman, Rob Kaufman, and Tim Briggs, and the chairwomen of the Subcommittee on Family Law, Cheryl Delosier and Tina Davis, for holding this hearing on House Bill 1397. House Bill 1397 would create the presumption that between 40 and 60% of a child's time should be spent with each parent. That is, that such an arrangement would be in the child's best interest. If a judge decides that it's not, and that certainly will happen, the judge must put down the reasons for that decision in writing. The other thing this bill does is more subtle. It changes the terminology and some of the language in existing law to move away from an assumption that one parent is better than the other, or that one parent is less fit. While this may not have an obviously legal effect, I believe it is important because it shifts the way we are asked to think about parents and their relationships with their children and with one another in this society. As a legislature, it seems that child custody is one of the issues that never goes away and is never easy. There is no simple answers, and it seems that often the very solution that would make the world right, again, for one family would create havoc for another. And also, while the legislature is tasked with creating policy, the judiciary is tasked with exercising a degree of discretion within the statutory framework. So the question becomes, how do we as legislators do the very best job we can while at the same time allowing judges to do the very best job that they can? As I said, there's no easy answers, but I look forward to hearing the perspectives and suggestions that will be presented here today. Thank you.
Thank you, Representative Helm. Before I call up the first testifier, Steve Meehan, if you want to move up, start moving up, and then, but also to mention that obviously I've talked to a number of people in my office as well on this bill. It is an emotional issue. It's a very personal issue for many people in this room, and I would simply just put out there, if we could please respect those that are testifying. We have differing views in this room, and both of them are important, and that's why we're having the hearing. So with the amount of people that are in this room, I would ask that let the speakers speak, and if you have something else to add, we can do that afterwards, but please respect those that are speaking in their opinions. So with that, Steve, I hand it over to you.
Good morning, and let's push check one. Does it seem to work? Whoops, is that working? Oops. That's one way to do it. Check, there we go. Thank you so much. We're very grateful to be here today. My name is Stephen Meehan, and I actually was a former House staffer here on the Judiciary Committee and sat on the other side of the podium in a former life here. I am back before you today on an errand of love. I am serving as a volunteer chairman for the National Parents Organization. And around the nation, we have state affiliates that have been working with legislators and staff and are working to bring us closer to having a typical result being equal and shared parenting around the nation. We are grateful to my representative, State Helm, very proud to be in her district and proud that she has given our attention and allocated staff to help with this. I did want to mention that we are grateful to my close friend, Bruce Hanson, and the staffer that was assigned, Anna, to their help in drafting this very important bill. And I have to say, from the time that I spent in the legislature, this one is so very important. It is governing our most sacred bonds, and that is parent and child. Next to me, I have Mr. Matt Hale. He is from Kentucky, and in Kentucky, we did implement a similar bill, and we wanted to make sure you were aware of the results down there. So I will be referring to him. He did include some PowerPoint slides that we will get to. I'm going to be much more brief than my written testimony was submitted today, just to help move things along. I'm not here to discuss my personal case, but I am here to speak on behalf of families seeking child custody reforms. You will find me using the word we, and that's not only the National Parents Organization, but that is all non-custodial parents, their family, their grown children who have been through our family law and courts. Today, we are here, and the laws that we've watched and have been normalized once upon a time included slavery. Once upon a time, there was a time when it was normal that women weren't allowed to vote. We've been through a lot, and unfortunately, we still have normalized some things that we believe should not be normalized, and I'm referring to the ease at which we designate non-custodial parents and create them. We would like to see the exception, which is about 15% of cases today in Pennsylvania, result in an equal shared parenting arrangement, and we believe that it should be reversed, and we believe that we would have a much healthier society and families if we get to that, and we believe that this bill will bring us closer to what should be normalized. There are some concerns that we have encountered in other states that came from bar associations and came from domestic violence industries. What I want to refer to next is the results from Kentucky, because we can address those concerns not by guessing, but by the actual results and the statistics of this act in Kentucky. And to that end, let me introduce Mr. Matt Hale, and he will inform us about the results of Kentucky.
Well, what a great day. Thank you to everyone on the committee for getting together and talking about what we can do to help children get to see both their parents after families separate. I'm Matt Hale, National Parents Organization Board of Directors member, but I am not here today as an advocate. I'm here today as a scout. I have walked the path that you are considering today. I initiated our nation's first shared parenting presumption law in Kentucky and led the effort for its passage. Kentucky's shared parenting law passed with enormous bipartisan support, 81-2 in the House and 38-0 in the Senate. The governor signed it into law, and then both parties tweeted out proudly about its passage. Kentucky joined together to do what's right for kids and pass a law that will one day be the law in every state, including Pennsylvania. After the lawmakers spoke so strongly with their votes, for the first time ever, American citizens got their say about an actual shared parenting law. And the voters spoke just as strongly, approving the legislation by a factor of almost 6-1 in polling. And what did the voters think of the lawmakers who passed the nation's first shared parenting presumption? They said 61% to 11% that they would support those lawmakers. And a few months later, the voters didn't speak at the election, they roared. There's a chart in your packet there that shows the results from the Kentucky election, and it's a straight line for the sponsors. 100% of the sponsors won, 90% of the yes votes, 80% of those who abstained, and there weren't many who voted against, but you can see what their re-election result was. The law's popularity has grown even since then, with the state proclaiming the day it was signed as Shared Parenting Day forevermore. And the law will forevermore help Kentucky citizens. For instance, it's saving them money and lowering parental conflict. This is not a guess. The Administrative Office of the Courts issued an official report comparing domestic violence family court caseloads. And you can see the first year in that study is the year before the shared parenting law passed. The second year is when the temporary law portion of the law passed. And the third year is when the full-blown permanent custody law passed. And domestic violence cases went down. Fewer family cases means a lighter load on the judiciary, and that saves money. And that's the wonderful path that you're beginning now. Bipartisan unity, greater polling, happy voters, less parental conflict, and lower court costs. But the greatest step on the journey that you're undertaking right now will be the day that an alienated parent calls you with joy in their heart, saying that they get to see a child that they haven't seen in many years. And that's the real benefit of the walk you're taking. I have faith in everyone on this committee. You want what's best for your state's children, and that's the reason why you're considering shared parenting today. I look forward to taking this walk with you. Thank you.
So as it relates to scaling to Pennsylvania, just the math behind this, there are 48,000, between 46 and 48,000 cases of child custody that come in each year into our courthouses. As you know, we have 67 counties across the state, and you can imagine every day, as of today, we're producing thousands of cases over the course of a week that are resulting in non-custodial parents. That's a lot of voters. You can multiply that by 8 if you consider the 2 sets of grandparents, 2.5 children, the siblings, the aunts and uncles, the grandparents involved. That's a lot of people. That's a lot of people that are affected by one custody case. We must look at a custody case in terms of that. It's not just a mother versus a father. These are whole families involved. That math shows you over the course of a year how many people are deeply affected by this. When I walk around the Capitol and met with state representatives and their staff, all of them had told me that they personally have their family touched by this. So if you consider that math, this is a very significant issue, and it will affect a lot of people. And this is an issue that is very determinative. A voter will vote someone out or in based on this one issue. And you can tell from the room behind me that most of the people behind me are not just individuals, but they're also here representing larger communities and groups. There are too many to list. We've had Dr. Childress in before testifying in this room with a parallel approach to solving parental alienation, which is often a typical result when we assume that there is one primary parent and one lesser parent. It's only natural that people within your own family, your own children, see one as more important. One gets marginalized. And the statistics that result from that marginalization involve childhood traumas that we hear today. We hear today in the news a focus on the importance of not separating parents and children who are actually breaking the law coming across the border. And there is a great amount of concern for them being separated, while here in Pennsylvania we have 67 courthouses right now routinely separating or mitigating a parent's child and parent time. I haven't met the legislator yet who doesn't feel uneasy about the prospect that if their marriage fails, that they will go before someone that they don't know that well, who just got elected, and will tell you when you can love and see your children. It's the most basic bond. We need to have a more predictable outcome. There was testimony on another House bill in judiciary that regarded grandparents' rights, and we wanted to create a law with more certainty. The testifier said we want our society to have some level of predictability that our bio-grandparents and that our parents will be involved naturally and, as to be expected, a presumption of their relevance in the life. And we ask that we afford parents that same predictability. It will reduce conflict. It will reduce trauma on the children. And it has proven to reduce violence. We are not asking that we, at this time, change anything with regards to any kind of criminal behavior that was involved or convictions. That's still there. It's unchanged. This bill would not change that. But we would ask you to try and take this small step forward so that we normalize parental involvement and equality and render the 15% being the sole custody, and at least require our judges to give a factually based rationale for not awarding that. And that's what we're here for today, and we're very grateful once again for this committee's attention to this issue. We know that it's a long one, it's a very passionate one, and we hope that you will continue to seek more information and results as it is occurring. I believe it was just introduced in Florida the other day as well. It is going to become more normalized and more expected that we find a way to split custody more equally. Anything to add, Matt? No. Okay.
Thank you very much for your testimony, and at this point, there are no questions, so I appreciate your time and effort and the information that you shared with us.
Thank you so much, Cheryl.
Thank you.
All right.
I'd like to call up Gail Calderwood and Michael Burton from the Family Law Section of the Pennsylvania Bar Association. I believe Michael is speaking first.
Good morning, Chairwomen Delosier and Davis, and members of the subcommittee. Thank you very much for giving us the opportunity today to speak with you all on what is one of the most important topics that we could come across, which is children. My name is Michael Burton. I'm a family law attorney for about 20 years. I wear many hats. So I also am a fellow of the American Academy of Matrimonial Lawyers and a member of our Joint State Government Advisory Committee on Domestic Relations. But today, I'm wearing my hat as the chair of the Family Law section of the Pennsylvania Bar Association. And I'm here today as the voice of the approximate 24,000 members of that Bar Association across our entire Commonwealth. And I'm here today to express the association's opposition to House Bill 1397. It is my understanding that the common goal of lawmaking is to evolve and to continue to perfect and best suit the common good. In child custody laws, we have seen consistent evolution. And the evolution that we have witnessed over all the many, many, many years is to continue to perfect the focus of our singular goal, which is the best interest of the children or child in a case. And because of that, we have eradicated over the years all presumptions in our custody laws, but for one, which is a parent versus a non-parent. And in doing that, we have shifted the focus solely on the child, which is our most important issue. And what we did with our laws when we revised them most recently in 2011, 2012 is, and I'm touching upon what the speaker said just before me, is we are focusing on a 16-factor analysis that every court must use in making a child-centered custody determination. And the law is such that the courts must state their reasons on the record and in their order of each factor. And it's 16 factors. And it's actually more because the 16th factor is a catch-all. So really, we're looking at more than 16 factors. And our appellate courts have stated that if the court misses one factor, it's reversible error. That's how strong and detailed it is. So in the evolution, what has happened, we could trace back to year 1813. That's when a presumption started called the tender years doctrine. And under that doctrine, a child that's 7 years or younger was presumed to be in the custody of mother. Before the tender years doctrine, there was an opposite doctrine and laws that the child was the property of the father. It took over 100 years for that presumption to be removed by our Supreme Court. That happened back in 1977 and got finalized in 1980. And so what happened then is we then started having our sole focus on the child. Now here's the danger about presumptions. When you have a presumption, you are now focusing on parents. And it is a very sensitive issue because everybody can empathize with a parent and what they would want and what the custody would be. But we can't lose sight of the focus, which is the child and the child's best interest. And so I just want to throw something out there. For example, and I think this bill, with a presumption of this type of equal share in custody, can invite litigation. And so in our support laws, if you have even custody time, the parent that makes more pays. And so if you have a situation where a father has primary custody and has had primary custody for, say, 5 years, 8 years, 10 years, because mother might have been an absentee mother in that family. And so what happens is he might make more money than mom, but needs some support because everybody owes a duty to support their children, right? And so he then seeks support from mom. With this law, mom could then just file for custody, and the way that, and Gail's can explain with the burdens of clear and convincing evidence, it'll be pretty hard for an order to come out of that situation that's not in an equal order, regardless of what the history was for that child and that family. And what's the focus? The focus there won't have been on the child. So I want to just read you one quote that's very powerful, and this really sums up, and then I'll, as my old paralegal used to say, land the plane. So here's this quote from our Superior Court. It says, "A presumption itself contributes no evidence, and has no probative quality. It is sometimes said that the presumption will tip the scale when the evidence is balanced. But in truth, nothing tips the scale but evidence. And a presumption, being a legal rule or legal conclusion, is not evidence. In deciding a child custody case, one should avoid the use of a presumption, which tends to focus the analysis on the respective rights of the parties, rather than on close scrutiny of all the particular facts relevant to determine what will serve the child's best interest. That shows you the evolution that we are experiencing, because now we have that analysis, the 16-factor analysis, and we are not walking into a courtroom focused on the parents. It's the child and an order that will be specifically tailored for that child's sphere around him or her. I want to give you 4 points, and then I'm going to pass the mic. There are 4 misconceptions I see often as a family law practitioner, and they will be negatively impacted by this bill. One is that fathers only get every other weekend or marginalized or minimal custody. In my experience, that's not the case. And that we don't have fathers that have been primary custodians. That's not been the case with me either. And also, there's this assumption that it's always an intact family separating, and then they're coming to court. But that's not always the case. You could have many situations where they were never married and never lived together, and a parent was never involved. And so you're not preserving a status quo of a recent separation of an intact nucleus of a family. Why do we have these type of orders? Many with equal custody now, and with fathers having primary, because we have an important provision in our current law that says, it says no party shall receive preference based upon gender in any award granted. That's strong and important language in our law right now. So, in concluding, the evolution has been terrific, and our laws that we have now are working very well. Sure, you're going to have some outlier cases and situations where somebody's not satisfied, but our focus currently remains on the child. If House Bill 1397 becomes our law, our evolution is going to freeze right in its tracks, and it'll be worse. We're actually going to go backwards, and we will not be focusing on the child, which is our sole and most important focus that we all can have. I thank you all for having me here today. I really appreciate it, and I appreciate the large amount of people that have turned out today, because this is an important issue. Any questions, I would love to answer. Thank you very much, everybody.
Hello, my name is Gail Calderwood. I'd like to apologize for my voice. I have a bit of a cold. I would like to thank Chairwoman Delosio, Representative Davis for having us here today, and to all the members of the Judiciary Subcommittee for having taken the time to listen to what we have to say and to read the testimony from all the witnesses today. As Mike Burton said, this is an extremely vital, important piece of legislation because it fundamentally alters our custody laws in Pennsylvania, laws that have been in place for some time but have been altered over time with input from our section, the family law section of the PBA, the Pennsylvania Bar Association. I am the immediate past chair of the family law section. Mike took my crown in July. We serve for a year each. We represent over 1,000 practicing family law attorneys in Pennsylvania, the bulk of whom solely focus on family law. And I will tell you, it's not the most popular thing to practice as a lawyer. It doesn't pay well, it's tough, it's emotional, it takes a toll. But we have a shared goal of the family law section, which is to meet the needs of the parties and the citizens of the state, meet the needs of children in custody and support and related cases, and to reduce litigation. It sounds like an oxymoron, but we have pushed for legislation that literally reduces the work that we would have to do, because we know that increased litigation is negative for parents and children and takes an incredibly bad toll upon small children and even teenagers and even adult children in a family. It's very difficult for people to go through these things. And custody in particular is probably the most contentious, most difficult area of practice. The children do suffer the more the parents fight and go to court. Now, looking at this statute, I think everyone in this room has shared goals. We all would like to make things better for the children. But how to achieve those goals, we have differing opinions and differing methods. And I think it's important, as Michael said, that the laws that we have in place now have evolved literally over 100 years and have shifted away from presumptions. And in part, that is because judges are humans. And when they see a presumption written into the law, they tend to treat it as a rule that cannot be changed. Even if you provide for exceptions to the presumption in the past, they proved very difficult to impossible to overcome. So as lawyers, we, over the decades, became anti-presumption, and the courts share our opinion because the courts saw the cases come through and saw the end results. We are on the front lines of dealing with this issue. We see a multitude of families of different types and people with different issues. And while the people in this room all have shared interests, they have different experiences. And some people in this room may view things a certain way, but as Michael said, there are some assumptions that we have heard mentioned that are not true. One assumption I heard is that the courts think that one parent is automatically better than the other, and that is absolutely not true. People come to court on equal footing. The court focuses on the factors, and each party has a chance to argue their case. And in fact, I've practiced over 20 years, and I've represented a multitude of fathers who have been awarded primary and/or sole custody of their children due to serious issues within the relationship that the children have with the mother. And I also represent grandparents and aunts and uncles and great aunts and great uncles who have taken over the care of children because of serious problems within the family and have primary and/or sole custody. So there is no assumption in our court. The focus is on the best interest of the child. This statute has, unfortunately, some serious problems as we view it from a legal standpoint, but also in the practicalities of how it would affect families. It creates, as Michael mentioned, a very high evidentiary bar. It uses the language clear and convincing evidence. That has real meaning in the courts. It has been defined by case law. Both attorneys and judges understand that to mean the highest bar, the biggest hurdle to overcome when you go to court and have to argue. You have to have evidence that is both clear, direct, weighty. Your testimony from your witnesses has to be clearly understandable and not open to question. But that's not what happens in a custody case. In a custody case, 99% of the time, it's he said, she said, from one parent to the other. You don't often have third-party witnesses in your home day to day watching you while you raise your children, watching you take them to school or get them dressed or do their homework. The only people who can testify to the majority of the evidence is parents. And so again, it becomes a he said, she said situation. The courts rarely have a situation where they're looking at clear and convincing evidence in a custody case. They're looking at those factors, they're looking at the credibility of the witness, and they're making a decision based on all of the evidence without any presumption. And that is a very key thing for the children involved. The children deserve to have their needs considered. And with clear and convincing evidence, the case law has stated that the trier of fact would have to be able to make a decision that is one of clear conviction without hesitation of the truth of the precise facts at issue. Now, that may sound like a bunch of words, but what that means to lawyers and judges is you have to be crystal clear. You have to know exactly what the right result is. That is not what happens in custody cases most of the time. Most of the time, the court is trying to determine what's best for the child, not what's best for the parents, and there's not crystal clear evidence that it should be shared or it should be primary or should be sole, although maybe in sole custody there tends to be more crystal clear evidence. But what we need to do is to allow the judges to weigh the evidence, allow the parties to present the evidence and argue the evidence. And if we put a clear and convincing standard in, which in the civil courts is the highest standard, we prevent that from happening. I think that it is important to remember, too, that there are some issues in the language of the statute where it's eliminating terminology and introducing new terminology that will clash with other statutes that we have and other rules, including the support rules that we have in place. It also, I would like to note, and based on my experience again, but also the fact that we've dealt with it in my immediate family, it will not cure parental alienation. Forcing children to spend 50% of the time with two parents, one or both of whom are trying to carry out parental alienation, will not solve the problem. It just puts the children in the middle of the war, literally. And it makes the children think it's their fault, it's difficult for them. What we as practitioners have been told for over a decade now by the experts, who I think you'll hear from, is that intense counseling is what cures parental alienation, both for child and parent, not forcing time. Now, there are cases of parental alienation where the court would order 50-50 custody despite the parental alienation. In fact, as Michael mentioned, that is the trend in family law. And again, that's another assumption I heard stated today that was incorrect. Most cases resolve out of court. Of the 100 cases we might have a year in our firm, probably 85 to 95% of them will resolve outside of court. Sometimes parties will start the court process, but very quickly reach a settlement, often with some input from the judge or a master who's assigned to help out. But it is still not a litigated result. It doesn't go to a full hearing. Putting language that creates a presumption in the statute, parties will latch on to that. They'll say, well, I could get shared custody 50-50. I want that. They will be less likely to settle for 55% for mom and 45% for dad, or dad getting 60% and mom only getting 40%. They are going to want to fight. And I can tell you as a practitioner, the hardest thing is talking your client down off that ledge when they want to go to war. What we try to do in custody is prevent those wars. We want people to resolve their issues, be creative in how they resolve their issues, and look at all of the factors when they do that. Their job, the distance, do they travel for work? All of these things impact how they can parent and what time they can spend with their child. I would also like to say that from the standpoint of grandparent custody, I have concerns with this statute that it negatively impacts the rights of grandparents that have been created by the statutes that we have in effect currently. And that will be, I think, expanded upon by subsequent testimony, but I do believe that it particularly eliminates the ability to achieve partial custody for grandparents, and it could even negatively impact the parents themselves and the child, because it could grant grandparents 50-50 custody more often than would ever happen under current statutes, and that would be viewed by many parents and even the children as an interference in their normal day-to-day routine. But we can expand upon that with further testimony. Again, I have represented a myriad of cases where mothers do not get shared or primary custody for a variety of reasons. We see cases where parents have mental health issues, drug addiction issues, prison sentences, abuse perpetuated by that party. We see parents who simply cannot be a parent and are gone from the child's life for years at a time. We hear the worst stories and we deal with the worst situations that you could imagine. But yet we are able to resolve most of those cases out of court to the benefit of the child. This statute would make it far more difficult for us to do that. So I would ask you to please consider not passing the statute as written. And thank you again for listening to our testimony. If you have any questions, we are available.
Representative Helm?
I just, in talking about this bill for the last probably a year, I've had a lot of parents come to me and feel that they leave the court and they don't know why they got the percentage that they got. This bill says that the judge must put it in writing, and I think that's very important. So why do you think that that's not important?
Currently, by statute and case law, they are required to put those decisions in writing. It first started that they were to put it on the record at least. Now it's been perfected. Again, evolution, as I say with law, that they are to. So it's disappointing to hear that you have come across some litigants that have had that experience because they shouldn't have that experience. Again, and I don't mean to minimize this, when you walk down the street, you've got good dentists and good orthodontists. When we were shopping around for my kids' teeth, sometimes, you know, you have somebody that does a better job than the other. We do a check and balance system of appellate work to be able to correct those issues. But if something like that happened, as you explained, and that case was appealed, that would be a problem for that trial judge. In that case, they should definitely know. And that was part of what we put together in our statute that came out in 2011, 2012, and perfected since, that litigants should know why a decision was made and why there might be an extra night here or an extra dinner here or what have you. Thank you for that question.
Well, I just think you said about good and bad in every profession, but I think this will make every judge pay attention more to what's happening in court, and the outcome will be a lot better. So I appreciate your testimony because we want to hear pros and cons, but obviously we're all here today for the betterment of the child. I mean, that's what our all concerns are. Exactly. So thank you.
And also, and I neglected to mention, we had Representative Rothman join us, as well as Representative Tara Toohill and Representative Paul Schemmel, and also our chairman. So with that, I'll hand it over to Representative Toohill.
Thank you, Madam Chair, and thank you for being here today. So just to clarify, currently, is there a presumption that, you said the presumption flipped, that after 100 years, mother became the the children were property of mother, that was an evolution that was created after 100 years in the law, and now what's the current status quo presumption?
So I say I'm happy to announce, because I think it is terrific for the child, that we are a presumption-free state, with the exception of a parent versus a non-parent. So in the early 1800s is when that presumption for mothers of tender year children of ages of tender years came into effect. That then got, I'll use the loose word, abolished in 1977, okay, and solidified in 1980 by our Supreme Court in Pennsylvania. And since then, since 1977, we do not have any presumption with regard to child custody. So when parents, as Ms. Calderwood stated, walk into that courtroom, they are on equal footing, and there is no tilting before they walk in of the scale. And the court has to look at those 16 factors and analyze each one, and then make their decision on the record in the order, so everybody knows how they analyze. And they actually have to enumerate each of the 16 factors. So it's not even, I just want to expand what I said to Representative Helm. It's not just that they have to say, here's why I did it. They actually have to go through each of the 16 factors and state why this one factor weighted in a different way than another, and why this one was considered as it was, and why this one didn't quite apply to this child. And they have to go through all. And what our appellate court said is, if you skip one, got to go back to go, okay? And they have to redo it. So it's complete transparency, but there is no presumption, because we're focused solely on the child. If we do that presumption, we're shifting that spotlight.
And so you use the terminology parent versus non-parent?
Yes.
And is that the same as custodial parent versus non-custodial
No.
parent?
So a parent versus non-parent, I would mean that if I would be against somebody that is not related to my child and has no relation to our family, were to come in and say, I want some custody time of your child. But whether you're primary custodian, partial, equal, they're all treated the same. It's only when somebody's coming from the outside of that family and trying to come in, they give a preference off the bat to the parent. It still can be overcome, but there is a presumption that the parent can hold out against outsiders. Okay.
And so in the initial stage of these proceedings, families get paperwork and it states custodial parent and non-custodial parent?
Not
They do not.
necessarily. So you can have a situation where they both will be custodial parents. So if somebody has
Or
more
primary.
time than another, and in reality, the way our statutes written, and some people can get tied into the semantics, if a parent has like 3 hours more on a year, that person's like technically could be considered a primary custodian. In reality, that's a shared physical custody schedule, but a primary custodian is the parent that has more time. The partial custodian is the parent that has less time. Sometimes we're talking about Sunday night, right? But that tips the scale where one person maybe has a little more time and makes them the primary custodian. But it doesn't mean that a other parent is relegated to, just having a dinner or something like that. Like if you come across a situation where one parent just has some dinners or something like that, there probably was more to that case because that's pretty extreme. So if you have a situation and there's not a lot of red flags when going through the 16 factors and the history of that family and that child, you're going to come out with, and there's no travel issues like where someone lives 5 hours away or something, you're going to come out with a case more closely of a shared situation. It's when there's issues, when that comes. But when we have these presumptions, it's an easy ticket out. So that you walk in, the judge might say, just like Gail said, the bars here, they're not meeting it. 50-50, okay, next case, Smith versus Smith, instead of getting into the real details of that child with that child's circumstances, that child's special needs if they have it.
Okay, that's helpful. It's just been in my personal experience that families are very tied up into the semantics of it,
Right.
and getting paperwork where something is referencing custodial versus non-custodial or primary versus non, that creates a litigious atmosphere from the beginning.
And you'll hear later that there is a review going on with our current statute, and our later speakers will talk about it. And that is something, for us to look into on some of the semantic side of it, to make sure that things are clear, because there has to be sensitivity in titles and in words. I mean, in some instances with schools and such, some of that is needed for them to do their administrative work and what they have to do, joint legal custody, things like that. But that is a great point that you raised. Thank you.
Thank you.
Okay, thank you. And we're running out of time. I have one quick question is, one of the issues that have come up time and time again with folks that I've spoken with is the issue that one parent might have only 3 hours or have a very limited amount of time with a child, but yet that time keeps getting messed up. The person's late dropping the child off, or there's a certain situation. The frustration that has built constantly is they only have 3 hours.
Right.
And the other parent is messing up that 3 hours.
Yes.
So they're frustrated alone that they only have 3 hours.
Right.
And even that 3 hours is being messed up, but they have no avenue in which to go and seek a remedy. So what would be, because, and money is the issue. I mean, we can't go to a lawyer, nothing against the Bar Association, but we cannot go to a lawyer every time something happens. It's expensive, and people do have limited resources. But their frustration levels grow and grow and grow when they have a limited time, and that is still being messed up, and nothing happens to correct it. And they don't have a hearing date for 6 months, and it's continually happening. What would you say in the sense that their frustration level is, and what is their resource, or what is their outlet to see some remedy to that?
Actually, there's quite a bit the parties can do, even on their own, in representing
It
themselves.
doesn't seem to be happening. That's what I'm saying. Stop. Because we have a lot of people we can exchange you with outside, so please.
So in most of our county court systems, there's a system where you can go into court and bring a motion. The majority of the counties will allow a motion with so many days' notice. It could be 4 days, it could be 7 days' notice to the other party. You're asking the court for relief at the motion. The court is a court of equity in family law. That means they have broad powers. They can order sanctions, they can order per diem fines. That means per day, each time there's a violation. They cannot modify custody based on a contempt, but they can order a contempt hearing, hold the party in contempt. Now, if you go to court on motions or you have a finding of contempt, that provides a basis to then file for modification. So parties can then file for modification and say to the court, there is a pattern here. This is their MO. They're interfering with my time. They're interfering, and it's not in the child's best interest. That could result in the party actually getting more time. It can result in a variety of outcomes. And we, as practitioners, have seen both lawyers be successful with those actions, but also pro se people. I have seen people represent themselves ably and well in family law, sometimes better than some attorneys can who dabble in family law. I mean, it is a system open to all. There's no
And I
closed
understand
door.
that, and I know what it's supposed to be.
Right.
Unfortunately, the people that were sitting across from me did not have that situation. And
And
time and time
right.
again, they do not have a hearing for months. And it happens they only have 3 hours that week, and they have not seen, or they've only seen the child for an hour and a half, or they only see, and it happens over time and time again. In some of these cases, we're talking about young children who that bonding time is limited to begin with, never mind the fact that when you only see that child. And there's no fixing it, and they're at the mercy of the other individual. And as you well know, in family court, it is an emotional issue, and obviously they wouldn't be divorced if there hadn't been issues to begin with. So the ability for us to have that is, I think, a huge issue that we need to address, because they have no outlet, at least that they have access to.
Just so I'm clear, though, in your hypothetical, would that be after a hearing that the person got the 3 hours? Because if it's before it, when you're, say,
It's
on
both.
deck, like you said, and there's many months away, when there's not an order in place, and I'm very empathetic because I come across this issue that you're talking about, that there's nothing to enforce.
Right.
So,
Well,
you know,
and the arbitrator, that they don't go in front of a judge all the time. The judges, sometimes those hearings in front of judges are way out, and they have to go in front of an arbitrator that very
conciliator
much
or
is
something.
biased one way or another in their opinion. So I just bring that issue up as it was something that I've seen a lot come in the office, and that.
Well, if I could just respond further to that. We have discussed with the legislature over the years ways to try to solve some
Yes.
of those problems, which could be legislation directed just toward violations, toward contempt and timing issues. But revamping the entire custodial
And then right.
statute is a
But that is
totally
an
different
issue at this point in
yeah.
time. And giving back time, I think, is something that is, and I know the Bar Association has discussed that as well.
Supports that.
Right.
So, and I thank you for your testimony then. We will
Thank you all
continue
for
on.
having us.
Thank you. Running a little bit behind, but here, the next testifier is Justin Poe and Mark Ludwig, the Executive Director of Americans for Equal Share Parenting. If you guys can come up and give us a short overview of what it is that your group is participating. Thank you.
I'd like to thank the members of the committee for the opportunity to testify. My name is Justin Poe from Chambersburg. I'm a leasing and rental assistant. Member
Can you
of the-
use the microphone, please? Nobody can hear you. Thank you.
I'm a member of the Chamber of Commerce and a Rotarian, and most importantly, a father of 3. I spent more than 5 years fighting for custody of my oldest daughter. I have 3 children, one I adopted. I was alienated from my oldest daughter for 4 years when her mother unexpectedly passed away, and I went from court-ordered supervised visits to full-time.
I'm very sorry. There's a lot going on out there. Can you pull that mic closer? Because we cannot hear you. And we're sitting across from you. Thank you.
I went from full-time supervised visits to full-time dad overnight when my ex-wife passed away. I went on to marry, and I legally adopted her daughter. The adoption degree reads, the best interest and welfare of the person proposed to be adopted will be promoted by such adoption. And 2 years after we were married, we divorced, and that's when I started to lose custody. I found myself in court again. I spent 11 months in court and about $10,000 in legal fees and received about 40% custody. The new visit schedule didn't work with my ex-wife's schedule, so we worked out a 50-50 agreement between the two of us. And after the two of us started getting along and I got 50% custody, my youngest daughter's grades started, to come back up, showing that it was the best move for her. She started to be more engaged in school, and at home. She is recognized as Student of the Week at her elementary school. She is more social and outgoing. When I got full custody of my oldest daughter, the stress of being alienated ended. We rebuilt a strong, healthy, loving relationship. I was no longer tied up with all the attorney fees and court costs and things, and I could afford to get her the things she needed, like braces, and she wanted a saxophone. It really started to encourage her. Her self-esteem started coming up. She joined high school band, jazz band, marching band, orchestra. She won a scholarship for her achievements in music. She joined the Shippensburg Community Band and volunteered at Network Ministries, teaching the underprivileged kids down there how to play piano. I purchased a better saxophone for her, and it motivated her to pursue a career in music, and she is in her second year at Youngstown State University with interest in teaching high school band or college-level music theory. But, you know, the 50-50 custody, it just, you know, my children's success and achievements prove clearly that the shared custody works and it's in their best interest. I understand there's isolated cases where some people shouldn't be involved, but the way the current family law and courts operate, willing and able parents are being forced out of their children's lives by the system. House Bill 1397, I feel, would reduce the conflict, protect a parent, child, and extended family relationships, and it would reduce litigation costs where the money could be spent on the children versus fighting, you know, everything out in court. That's pretty much all I have. Thank you.
Thank you. My name is Mark Ludwig. I do want to thank the members of the committee for taking the time to hear this issue, an extremely important one. Without going into all the details, out of respect for my son and his right to love his mom, shortly after my son was born, I went 204 days without seeing my son. At the end of that time, I was relegated to the equivalent of an every other weekend visitor. Shortly after that, I was diagnosed with a pretty large growth in my brain. We didn't know what my future was going to be like. And it dawned on me at that point, if something were to happen to me, my son's mom would automatically get sole custody. But it also dawned on me, if the situation had been reversed, I would have automatically gotten sole custody of the very son that I was already only getting every other weekend. Why would it take the death of a parent to convert from an every other weekend visitor to having full custody of a child? If that's the case, shouldn't both parents have 50-50? As a result of my story being televised on a news station in St. Louis, my story went viral. I think it's been 30 million views or something like that. And I started doing a lot of Facebook Lives. And my reach now is around 3 to 4 million in an average month. This past year, I did a tour of 38 cities in 24 states. And this isn't about me at all. This is about a fact that obviously this issue resonates. If we're attracting 3 to 4 million people every single month that are paying attention to this, and as you look behind me at all the people that are affected, this is resonating, and it's the only issue in 30 years that I've been around the political arena that crosses gender lines, crosses racial lines, crosses political lines, crosses socioeconomic lines. It affects everybody because we already know half of all marriages end in divorce. And for children, they have two traumas that they're dealing with. Trauma one is mom and dad aren't together. They don't know why, but they're very confused because they love both of them. Now add into that confusion, only one of them do they get to see on a regular basis. The other one is relegated as a visitor, which makes one parent in their mind the superior parent and one parent's the inferior parent. Now imagine that to a 7-year-old child or a 5-year-old child that doesn't know how to verbalize this confusion. And we wonder why, when we look at the statistics, between 70 and 94% of violent crime rates, incarceration rates, high school dropouts, behavioral problems, substance abuse problems can all be tracked to growing up, in many cases without the father. But this is technically gender neutral. I'll fight just as hard for a mother as I will for a father. But the situation can be solved so easy by starting the case with a 50-50. In every other area of law, we start out with a due process that says people are innocent until proven guilty. And yet we walk into a courtroom and one parent is presumed to have the upper hand in most cases. many of my followers and just about everybody in the room behind me will verify, most people I talk to say, you know what, I didn't have as much animosity for my ex until I met with my first family law attorney. And they told me that, look, in our state, you're probably not going to get 50-50. One of you is going to win, and one of you is going to lose. So unless you want to be the one that loses, you better start digging up dirt to prove why you're the better parent. And that creates this adversarial relationship, and that's why these court cases are drug out for 6 months, 8 months, 10 months a year. That's why, as we just heard, people settle. People aren't settling because they're glad that the arrangement, they're settling because they ran out of money and they don't have an attorney to keep fighting for them. Can you imagine how different it would be if those parents would walk into an attorney and the first words out of that attorney's mouth are, look, in our state, you're probably both going to get 50-50. So you might want to learn how to work together and how to co-parent for the betterment of your child. And now all that money, instead of going to the attorney's college fund, can go to their own college fund for their own kids, instead of having one parent ripped out of that child's life. And so to continue on a path, and not in any way putting down the previous speakers, but to think that we're doing okay with our children across America and in the state of Pennsylvania, that people are settling and everything is fine, is almost like Mr. Magoo driving down the street thinking that everything's fine while everybody's running off the road behind him because he's cutting them off. That's the situation that we're in right now. So I thank you so much for taking the time to hear this case, but I beg of you, please, for the kids of Pennsylvania, give them a chance to not have one of their parents ripped out of their lives. Thanks so much.
Okay, thank you very much. I appreciate the testimony. We will move on to the next panel, and that is Suzanne Estrella, Legal Director of PCAR, and Danny Pato, Civil Legal Representation Attorney for PCAR as well.
It's up to you. Thank you to the chairwoman of the subcommittee and the chairman of the committee. We thank you for this hearing and inviting us to be a part of it. My name is Suzanne Estrella, and I'm the legal director of the Pennsylvania Coalition Against Rape. The Pennsylvania Coalition Against Rape works with a network of service providers that provide counseling services and rape crisis services to the victims and survivors of sexual assault abuse throughout the Commonwealth of Pennsylvania. Protection of children and healthy, stable families and a fair judicial process are values that we all agree upon. We want children to be happy and safe so that they can grow up to be happy and safe adults. We want to ensure the judicial process is fair and equitable and that all the citizens of the Commonwealth have an equal access to justice. However, for the victims and survivors of sexual abuse, sexual harassment, and sexual assault that I serve, a presumption that equal custody is in the best interest of every child creates a barrier to justice that these survivors would be forced to overcome. Sexual abuse, harassment, and assault are serious and widespread problems, and what we do and say about them matters. Child sexual abuse is unfortunately more prevalent than the rates of child abuse substantiation convey. And we know that only a small portion of those who experience sexual harassment, abuse, and assault report to law enforcement. And studies show that 1 in 4 girls and 1 in 6 boys will be sexually assaulted before their 18th birthday. And unfortunately, that is often by someone they know, including a parent. Now, I know it's difficult to hear about children being abused, but I speak on behalf and with the permission of a service provider in Armstrong County to present a story where a mother and a father were being divorced and were in front of a judge, and the judge said to this mother, if you file for a protection order, I'm going to remove custody of the child from you and give it to the father, because she had no one else to substantiate her claim that the child had told her that he was being abused. It was only her word. Once she began to seek services in Armstrong County from the local Rape Crisis Center, the child did then report the abuse to the counselor there. And the counselor was able to provide testimony, and I quote, "Dad puts his big ugly tail in my mouth." This resulted in a report to Childline, and a founded case of sexual abuse by the father was substantiated. Had the center not been involved, it would have been impossible for that mother to overcome a presumption in the law that they should have equal sharing time. We're not against equal sharing time, where both parties are able to provide loving and appropriate care for the children. We are against a presumption in the law that mandates equal sharing time with a clear and convincing evidence standard to overcome it. It just creates another barrier and would probably lead to additional not reporting. If you have a person who's in a situation where they're having to leave a partner, and most of the clients that are served are not married, where they're leaving a relationship for one reason or another, and they know that if I go to court, there's going to be presumed equal sharing time, they're not going. So again, we're adding to the barrier of justice for victims who are in situations where there is violence, child sexual abuse, and things that we all agree that we do not want in our communities. The current structure of the law allows for an impartial determination based upon what is in the best interest of each particular child. Pennsylvania Superior Court has described that the benefits of a presumption-free law. The court has stated that a presumption-free law permits the lower court to engage in full, fair, and comprehensive examination of the best interest of each child. In that same case, the Superior Court also states that a voluntary shared custody agreement is favored over a shared custody agreement imposed by the court. In an ideal circumstance, the Pennsylvania Coalition Against Rape does not disagree that children should have access to loving, healthy, safe, and cooperative family members and caregivers. However, our concern is that given the prevalence of child sexual abuse and the underreported nature of such abuse, a presumption of 50-50 time could tie the hands of judges to fully assess and understand what is truly best for the children. The factors enumerated in the statute for determining the best interest of the child currently will allow the courts to conduct a comprehensive review of all the relevant factors to determine what is best. If a court determines that shared time is best, the law as it stands currently provides for that, creating a legal presumption that must be overcome by clear and convincing evidence is an unnecessary and unduly harsh burden for the citizens of the Commonwealth that find themselves in situations that are less than ideal. We're grateful for the leadership of this committee in passing legislation that further protects victims, mostly the recent statute of limitations reform and other critical pieces of legislation. However, we do not feel that House Bill 1397 would accomplish the shared goals of keeping children safe and supporting healthy and stable families. In fact, the bill as it is currently written, imposing court-ordered scheduled time would undermine safety and stability for all. In its current form, PCAR opposes this bill. Thank you.
Thank you to the committee for the opportunity to have us testify today on House Bill 1397. My name is Danny Pettio, and I am the Civil Legal Representation, or CLR for short, attorney at the Pennsylvania Coalition Against Domestic Violence, otherwise known as PCADV. PCADV is the umbrella organization for domestic violence programs in the Commonwealth of Pennsylvania. We have 59 member programs that provide a variety of services that are included but not limited to counseling, emergency shelter, and legal advocacy to domestic violence survivors in all 67 counties in the Commonwealth of Pennsylvania. My particular role at PCADV consists of overseeing PCADV's 17 civil legal representation programs that provide free and expert legal representation in civil legal matters to survivors of domestic violence. PCADV recognizes that leaving an abusive situation is just the first step, and that litigation can play an important role in helping a survivor achieve safety, self-sufficiency, and autonomy. Whether that relief takes the form of a divorce, an award for financial support, custody of their children, protection from an abusive parent, secure immigration status, or any combination thereof. Also, before coming to work at PCADV, I helped start the civil legal representation program that served Luzerne, Carbon, and Wyoming counties. And as a CLR attorney, I have extensive experience representing survivors of domestic violence in contested custody matters. PCADV has significant concerns with House Bill 1397, particularly the presumption in favor of 50-50 custody, the modification of several of the 5328 custody factors, and the expansion of grandparents' rights, just to name a few. These proposed changes would create significant issues for the child custody process and make an already difficult process even more harder, dividing families and putting children at greater risk of harm. In regards to the presumption of 50-50 custody, it would put the cart before the horse, putting the wants of the parents ahead of the needs of the child. While we recognize that a relationship between a parent and child is fundamental like no other and is constitutionally guaranteed, we cannot forget that the child is an autonomous individual, deserving of life, liberty, and the pursuit of happiness. They are not a piece of furniture, nor are they a pet, subject to the equitable distribution rules as part of a divorce or a similar scheme thereof. The current statute gets it right. It puts the child first, requiring that the court's custody determination be based on the best interest of the child. House Bill 1397, its presumption in favor of 50-50 custody, is fatally flawed because it puts the parents and their interests first. Every parent wants to spend as much time as humanly possible with their child. However, contrary to what the proponents of 1397 would have you believe, it is not necessarily in the best interest of a child to spend equal amount of time with their parents. There are several reasons for this. First, the physical distance between the parties may make a 50-50 schedule highly impractical, though not impossible. A common example I faced in practice was the parents live 45 minutes away from each other. The child goes to school in mother's district, so during father's custodial time, the child has to get up an hour earlier and spend almost an hour in the car on the way to and from school. And I've had judges frown upon that based off of that schedule was not consistent with the best interests of the child. Another common reason is the parent's work schedule. Unfortunately, puts them in a superior position to care for the child. A very common example that we would find is one parent's work schedule has them starting work before the child needs to be on the bus and to school, and has their workday concluding after the child is released from school and picked up at the bus, making that parent impractical to get the child to and from the bus stop from school. Not a reflection on the parent's qualities as a human being and as their skills as a parent. It's just a work schedule that unfortunately is impractical for that parent to get the child to and from school during the weekdays. And finally, one of the main reasons that brings me here as a reason for not having 50-50 custody is the parent is abusive. And this is true even if the abusive parent never directly harmed the child. Abuse that a child can hear or see has been shown to have significant negative effects on the child's mental, emotional, and physical development. And what I'm talking about is the Adverse Childhood Experiences Survey, or the ACEs study. It is our position, and the position of common sense, that a parent who batters another parent is a bad parent. Indeed, this statute will be a boon to abusers who already have significant access and control over their victims by default, and abusers will use statutes and a severe presumption of 50-50 custody to enact further abuse on their victims and the children that are subject to the order. Compounding this problem is the presumption can only be overcome by clear and convincing evidence. As is said before by the previous witnesses, clear and convincing evidence is the highest burden of proof in civil law, generally reserved for matters where the state is a party and attempting to limit some significant right or interest. The main example that we provide is the termination of parental rights. A high legal standard makes little sense in custody, as families are unique and different and commonly require a custody award tailored to their specific situation and the specific needs of the child. The clear and convincing standard effectively makes it impossible to overcome the presumption for families and for families to seek creative custody solutions from the court. As a result, if House Bill 1397 is put into effect, the courts will be maintaining and/or establishing custodial relationships and schedules at the expense of the child's physical, mental, or emotional well-being. There may be situations where a 50-50 custody schedule is in the best interest of child, but that isn't always the case, and therefore it should certainly not be the starting point. The child's best interest, or the BIC standard, continues to need to be the lodestar. The next issue PCADV has is with the modification of that last 16th custody factor under Section 5328. The proposed modification of the 16th factor is improper because it doesn't concern the best interests of the child standard and effectively would create a retributive aspect to custody determinations. Currently, as stated before with our previous witnesses, the last factor for 5328 is our catch-all provision. It allows for the court to consider any other relevant factor that would go to the best interests of the child. However, House Bill 1397 would replace it with the existence of a prior custody order or parenting plan that grants an unequal parenting time for reasons not related to the fitness or interests of either parent. First, the factor does not address the child or their interests regarding a prior order that granted unequal parenting time. This is odd, considering the factors are to help the court determine what custody situation is in the best interest of the child. Second, as I stated previously, there is a plethora of reasons the parties may have entered into an order that provided for an equal parenting time that has nothing to do with the fitness or the interest of the parents. For example, work and school schedules, the child may have special needs and need special accommodations, child preference for those children where age and maturity is suitable to take their preference into account, and family structure. A lot of these reasons actually have more to do with the child than with the parents, and thus may have been in the child's best interest at the time the order was awarded. Proponents of this legislation may feel that inequitable custody orders should receive more scrutiny and redress, and redress is owed to victims of such orders. However, all this factor modification serves to accomplish is to make the adversarial process of custody even more so in allowing courts to consider this evidence in determining a custody award. Such factor would give custody a retributive angle that appeals to abusers seeking to have the courts punish the victim for seeking custody. Finally, avenues already exist for individuals to challenge unjust and unfair orders, and such issues should not be a factor in considering what is in the best interests of the child. And finally, PCADV has issues with the proposed expansion of grandparent custody rights under the 5325 section of the statute. It appears to be a solution in search of a problem. While there are issues with 5325 in its current form, House Bill 1397 is not the way to fix them. Indeed, it would make current issues even worse and create significant new problems as well. The purpose of 5325 is to help maintain relationships between grandparents and grandchildren that might otherwise be destroyed by death, divorce, or family estrangement. However, while well-intentioned, Section 5325 is not perfect on its face. The requirements for standing the right to bring a lawsuit under 5329 are astonishingly low. Something as minor as an acrimonious divorce and custody case where the parties disagree as to the extent the child should visit with the in-laws is sufficient to give grandparents standing to sue for custody under 5325 Section 2. As such, 5325 seems to fly in the face of the nearly universal belief that a parent's right to care and control of their child should be free from interference except for the other parent and/or in the event of abuse or neglect. 5325 is already regularly taken advantage by abusers who go through their parents to gain access to a child they have been separated from due to their harmful behavior. And in a specific case, I had exactly the case where the abuser's parents used 5325 Section 2 to secure custody, though the abuser had not been allowed to see the children because he had overdosed in front of them while they were with him on a visit. And the grandparents in this case did get significant shared custody. That being said, the low burden for standing is tempered in the existing 5329 statute and made acceptable by the fact that an award of custody under 5328 is currently limited to partial or supervised physical custody. As such, the potential level of access and interference is rather low. Accordingly, House Bill 1397 would give grandparents the right to seek the same level of custody over a child as a parent, even when the parents are taking adequate care of the child, would be a major and unwelcome change to the status quo. Indeed, given their stated position as to the importance of the parent-child relationship, I am struggling to see why the proponents of House Bill 1397 would support such a provision that would result in the dramatic increase in third-party interference between parents and children. I can only hope it has nothing to do with the fact that a proposed change would make 5329 an even more popular tool for abusers and their enabling parents. In conclusion, child custody is always a difficult and challenging issue, especially when the courts are involved. Judges and legislators are human. As such, no law or decision is perfect. However, with the luck and cooperation of people of goodwill, improvements can be made. Unfortunately, House Bill 1397 is not an example of an improvement. Indeed, it would be a significant step back. It would disregard the central focus of the child custody statute, the child, make the best interest analysis more difficult, and permit abusers and their enablers to manipulate the system and control their victims to an even greater extent. I urge the honorable members of this committee to vote against this bill. Thank you.
Thank you very much. I apologize. I actually lumped you guys both together for both with PCADV. Thank you very much. Representative Davis has a question.
Thank you for your testimony. I just have a question with the end of your testimony. So if my husband and I got a divorce and we had, say, whatever, 50-50, whatever, and my mother and I are estranged, my mother would have the right to sue for...
Under 5329, they do have standing to sue. However, they would have to prove, obviously, under the requirements of the statute, on the standing under the statute that exists and whether or not they meet those requirements. And factors such as estrangement and, obviously, the contact between the parties and the existing grandparent-child relationship would go into making that determination.
Does this bill change it to make it easier?
So what it does is the bill will actually, it does not change the specific statute in and of itself, but what it changes is the award that the grandparents would give. Under the existing statute, they would only be allowed to get either supervised physical custody or visitation. However, under this statute, 1397 would propose them to be awarded the same level of custody as a biological parent. That would be shared or primary. So we're looking at a higher award as opposed to a lower burden, if that makes sense.
Okay, thank you very much for your testimony.
Thank you.
And next, we have Maria Cognetti from Cognetti Associates, as well.
Judges.
I have them next. What are you talking about? I have joint government.
I think we were added to it.
Okay, by all means.
Is that all right?
Yeah. Okay. Wrong way. Different order, okay. Sorry about that. So we have Honorable Kim Eaton, Administrative Judge, Family Division, Court of Common Pleas, Allegheny County, as well as the Honorable Daniel Clifford, who is a Judge, Court of Common Pleas with Montgomery County. So thank you both for joining us, and the floor is yours. Thank you.
Thank you. We're certainly mindful that we're starting our testimony when the hearing was supposed to end. So we're going to try to just be very brief. We have submitted our statement. Let me begin by saying that I served in Montgomery County where I was elected in 2015. Prior to that, I was a family lawyer for over 30 years. during which time I served as the chair of the family law section of the Pennsylvania Bar Association. One of our initiatives that commenced under my year was to work collaboratively with this committee on legislation that began as House Bill 380, which was introduced by Representative Toohill, and which was approved by the House Judiciary Committee by a vote of 26-1, and ultimately signed into law by Governor Wolf as Act 102 in October 2016. So I start that by saying that we look to be collaborative with working with the legislature, not just the judicial piece of this, but also the lawyers as well. One of the things we're doing as part of the Joint State Commission Advisory Committee on Family Law, and I know you'll hear from one of the speakers after us, is that we're taking a look at the custody statute for recommendations to this committee and ultimately the Judiciary Committee with respect to the Custody Act and the factors. Both Judge Eaton and I have, Judge Eaton, by the way, has served as the administrative judge in Allegheny County, has been a judge since 1999. So you have in front of you a combined 75 years worth of family court experience when we present to you this morning. We should begin by indicating that our opinions are those of our own, including the response to questions, and do not represent the viewpoints of the Montgomery County Court of Common Pleas, the Allegheny Court of Common Pleas, or the Supreme Court Rules Committee, or the Administrative Office of Pennsylvania Courts. However, we do have a family law caucus among the judge group, about 85 judges, and we meet at least twice a year. And one of the issues that we discussed was this bill at our July meeting, and their concerns over this bill are reflected in our comments. I would like to start out, though, with something that Representative Helms said at the very beginning, because she nailed it right on the head, really, when she said that what works for one family could wreak havoc with another. And that's exactly right, because every child is different. Even children within the same family is different. And what works for one child may not work for another child. What works in one family may not work for another family. And that's why we're so adamant about not having presumptions. And for those of us who practice over many, many years, we were often frustrated by the reverse presumption that existed many, many years ago. We advocated for our father clients in the 80s and the 90s. It was extremely difficult to get, forget primary custody, it was very difficult to get 50-50 custody. And we feel as a group that we've evolved past that point. And Representative Toohill, when you asked about the presumption that exists now, we think that the wording in the current statute is exactly right. There shall be no presumption that a custody award should be to either parent. And from our experience, to answer one of your questions, Representative Toohill, I think judges rarely use those terms that you mentioned, non-custodial and custodial parent. We're talking usually about shared custody. Everybody who has custody has shared custody. Every parent has shared custody. It may be primary or partial in the viewpoint of actual time, but every parent has shared custody. Perhaps it's a manner of correcting the nomenclature, because I, as an attorney, as a judge, as a parent, I'm offended by the terms non-custodial versus custodial parent, because every parent has a shared custody schedule. The concerns that were brought up by Representative Helm, I have to agree with you 100%. There should be no litigant that leaves our courtroom wondering why we've entered that order. No litigant should leave questioning why we've entered that order. For years, we left the courtroom with our clients, and it was a 2-line order: custody to mom, every other weekend to dad. And that's the order that you were stuck with. You had no idea why that judge entered that order. There was no justification for it. The only way you could get an explanation of that order was to file an appeal and get a full opinion. But those days are past us now. You guys have given us the responsibility to address the factors As noted, they're 15 or 16, depending on how you look at it. We're required to do that. My factors go on for 25 pages. There's absolutely no mystery to any litigant in my courtroom as to what I'm thinking and why I've entered that order. Now, there's no requirement that it be in writing. It could be either verbally in the courtroom or in writing. Maybe there's a compromise to this approach to avoid having litigants questioning why they've left the courtroom, because even though the judge may go into the courtroom and recite the factors on the record, let's face it, they're not listening, they're waiting for the answer. They want to know what the result is. And maybe if they do see them in writing, there'd be a firmer way of having them have confidence in what the judge has done in that opinion. I'll turn to Judge Eaton now because I know I've taken up a lot of the time so far.
Well, one thing I do want to say is that I think most judges, certainly Judge Clifford and my colleagues, believe that children are best having a maximum exposure to both parents, all things being equal. So I want to start with that. But our job as judges are to be child-focused. And I think that one of the problems with a presumed 50-50 custody, it takes away a lot of the subtleties that I think go into what is best for the child, not for the parent. And let me give you an example. I live in Allegheny County, which is pretty big acre-wise, if you want to call that. I have cases where I have two really good parents. They fit all of those 16 factors, okay? But one parent lives an hour away. And in order to have a 50-50 custody, that child is going to spend hours and hours and hours in the car. I don't know if anybody here is old enough to remember the old Kramer versus Kramer movie where the child is left sitting at the door. I mean, when you have to travel that far for 50-50 custody. The other thing I see, and we are the boots on the ground, so many kids now, they have sports. They have activities. And in order to get this back and forth thing to go on, it's just not fair to have them in the car that much. And I will tell you, in cases when I have had a case where both parents are good parents, I have said, move closer for your child's sake, and I will grant 50-50 custody. But we can't put the kids in this situation. They need to have a home base, and if the parents live close enough, that's the same place. The other thing that doesn't have the subtleties is work schedules. Two very good parents, all right? But maybe mom travels all the time. She's always out of town, whatever it takes her. Then you have a child that's being raised by nannies or third parties. The problem is we can't get into those subtleties as soon as the case walks in the door. It takes a while for us to get to some of these subtleties. And I also wanted to respond as Judge Clifford did when Representative Toohey asked about, is it just the custodial, non-custodial? He said, we are required to go through those 16 factors, and I think it fixed a lot of things. I was practicing for 18 years before I went on the bench in family law, so I see both sides of it. And in those factors, mine goes on for 40 pages sometimes. And let me tell you this, the Superior Court takes those factors very seriously. If you don't go through each and every factor and either say what you thought about it and why you picked the way you did, including you have to say if, for example, one of the factors is drug and alcohol abuse. The Superior Court wants me to say I considered it and it wasn't happening in this case. I can't just jump over it. And if we don't go through all those factors, we get reversed. So I think we've fixed a lot of things with that.
Yeah, I think just to address some of the things that have been stated by some of the other witnesses today, I mean, we agree that children need both parents. I'm often saying a child cannot have too many adults who care about them in their life. We're often frustrated. I mean, equality sounds like a good idea. Who's against equality, right? I often say I wish there were 8 days in a week instead of 7 because it's hard to split that up. But just to reinforce something Judge Eaton said, I mean, a lot of times these kids are forced to spend inordinate amounts of time commuting to school with a parent, commuting to sports with a parent. Often a kid will end up driving 45 minutes to an hour just to effectuate a schedule that the parents want to have equal. They become known as the late child in school because of traffic and weather conditions. And these are all the kinds of things that we need to consider and have the discretion to consider as part of our role. I know that we attached to our exhibit the listing of cases one of your prior witnesses mentioned. There's over 40,000 new cases filed for custody every year. I know the chair mentioned her frustration or your constituents' frustration with the lack of ability to get in quick. This will not make things quick. This will require, at the initial filing, a determination by the judge as to whether the 50-50 time period is appropriate. Even though everyone else seems to think that that will end there, it won't end there, because you're going to have parents who are going to disagree with that, lawyers who are going to disagree with that, and we're going to be compelled at the very beginning of the process to have a full-blown hearing and address all those factors, which we're required to do after the case has sort of went its way through the system with conciliation and mediation. Many of the counties have these programs available to help parents resolve their case as opposed to litigating the case. Well, you're thrusting the families into a litigation mode at the very beginning. They will be litigating that case from the very beginning on this one point. And as we've noted before, judicial resource in terms of all, I mean, we already have existing cases on top of the new cases. We have modifications. We have other areas of family court we're covering. And in smaller counties, we're covering a lot of different divisions, not just our own division. So we ask that you keep all these issues in mind as you go about deliberating this. And again, I would like to say we are interested in collaborating with your committee as part of the Joint State Commission in a review of the factors. We've already started a 50-state review of all the other states' factors so that we can present to you at some point some that may be unique to Pennsylvania and some that we might like to fine-tune with our own factors. So we hope that you'll keep an open mind with that part of the bill. We do look forward to working with you on that part, because I know there was some suggested language change to the factors, which we're very interested in doing.
And if I could just say one more thing to Madam Chairman, who raised some issues about how things work in family court, and I hear you, and I agree with you. I agree with you. This bill won't fix it. It won't fix it. As a matter of fact, I think it'll make it worse.
Okay, thank you for your testimony. Representative Knowles, you had a question?
Yes, Madam Chair, thank you. And thank you, Judge and Judge, for being here, as well as all the testifiers and those of you who've come out, regardless of where you stand on the issue. Very complicated issue. It sounds to be very simple until you sit here and you listen to the testimony. People think that we as legislators have this magic wand that we just wave and problems go away. I have had fathers as well as mothers who've come into my office and who've said that the other is using the kids in custody as a tool. Unbelievable that anybody would put their kids through that, but they claim that that's the case. And I guess my question to you is the legislation, how do you think that would affect that situation? I mean, on the surface, when you say 50-50 custody, it sounds like a no-brainer.
It may sound like I said before, who's against equality, right? But for the child, from our responsibility is to view this in some respect from the child's perspective. And what works for one child will not always work for another child. So a 50-50 schedule may not work. As I pointed out, there are only 7 days in a week, so you got to cut that week up somehow, right? And the constant shift between households. Some of these parents, in order to do 50-50, they have the child sleeping at a different house every other night. How many adults would like to sleep in a different house every other night? And for a 5-year-old, that may not be appropriate. There may be a 6-year-old that would work for, but there may be another child that would not work for. Or if they're going back and forth every 2 days to another house. Or if they're going to do a 50-50 schedule, 1 week on, 1 week off, they don't see the other parent for a week. Is that a good result? So this is why we need the discretion to address every family as it should be addressed, with its special needs and considerations, what will work for that family best, and not approach it with a presumption that, you know what, go out and do 50-50. We don't really care how you work it out, folks. We don't care what the schedule is and the impact of that child. the schedule on that child. And that's why we're there, to design a schedule that hopefully will work for that family.
Well, I would just like to make a comment about that. Let's say we have, under our current factors, we have dad's the custodial parent. They break mom, so dad's the custodial parent. Mom doesn't fit any of the 16 factors, okay? Doesn't fit, all wrong on all of them. But mom says, you know what? Unless you agree to take lower child support, I'm going to take you in for 50-50 custody because we have a presumption of that. And I think it happens all the time. And I think, again, this will just make what you're talking about worse.
Thank you, Madam Chair. Thank you, judges.
Thank you for your testimony. And we will move on to Maria Cognetti with Cognetti Associates with the Joint State Government Commission Domestic Violence Relations Advisory Committee, as well as Mary Cushing's Dougherty with Hine Schwartz with the American Academy of Matrimonial Lawyers. Thank you for bearing with us. We're running about 20 minutes late, but look forward to hearing your testimony. When you're ready, please start.
Thank you. Good morning. Representatives Delosier, Davis, and Representative Helm, and other members of Congress, thank you for allowing us to be here. Mary and I will, I guess, be the cleanup today. My name is Maria Cognetti, and I'm a family law attorney in Camp Hill. I am the current and past chair of the Joint State Government Commission Domestic Relations Advisory Committee on Custody. I'm also a past president of the American Academy of Matrimonial Lawyers and a past president of the PA chapter of SAME. I'm also a past chair of the Family Law section of the Pennsylvania Bar Association. As Mike Burton pointed out, we wear many hats. My practice has been limited from the day I got out of law school over 42 years ago to family law, and most of my practice has been custody. I actually believe, although I've not done a statistical survey, that most of my custody clients are men. And I can tell you that my male clients would not like this bill. Good dads want and deserve the ability to go in and ask for primary custody. And I, for one, have a number of dads who get primary custody. This bill would basically take away their ability to do that based on how hard the presumption is. Interestingly, I noted in preparing for today that Mr. Poe, who is well known to many of us, states on his linked page that his objective, and I think we got this from his testimony, is to have equality between mom and dad when entering family court. That's what it says. He said today that his case shows that shared parenting works. I don't think there's any of us who have testified on this side of the argument that it does work. We agree it does work. It works in the right case. It definitely can work. We're not saying it doesn't. But our current statute, as I think many have pointed out, and Judge Clifford just emphasized, our statute already says that. It's 5327A. There shall be no presumption. That language presently gives parents equal footing while protecting the rights of the child and putting the child's best interest first. I'm not going to read my prepared testimony. Instead, I want to just hit real quickly on what we see as the major issues with the bill. First, as Gail Calderwell pointed out, and I think most of us have been stating, this bill is parent-centric. It can't be parent-centric. We can't be only about the parents. We should be about the kids. The bill should be kid-focused. This bill puts the parents' rights ahead of what is best for the child. I believe that Representative Helm acknowledged that sometimes there's going to be an order that's going to be other than shared. There might be a case where there would be primary. Absolutely, we know that's true. However, that belief and understanding leads to the second huge problem, and that's what we've all heard about most today, the burden of proof. If you have not read Gail Calderwell's entire written testimony, I would commend that to you. She covers the burden of proof very, very clearly, makes it clear just how difficult, if not impossible, it is to get past that burden. And that's not something we want in family law. That's why you never see that burden of proof in family law. It was also interesting to me to note that Matt Hale was here today from Kentucky. If you read my prepared testimony, and Judge Clifford doesn't know that I already finished our research on the 50 states, and in fact, the only state that has a presumption anywhere near what is suggested by this bill is Kentucky. All other states do not have that type of presumption. When they use the word presumption, it's where both parents agree there shall be a presumption, things like that. Neither parent is entitled to a preference, very similar to our statute. Custody is to be awarded without regard to the sex of the parent, again, similar to what we have. But there is no state, unless something's happened in the last week or two, no state other than Kentucky that has a statute even close to this one. And I believe, if I'm correct, Kentucky's presumption has a standard of proof below what is suggested by this bill. I also want to quickly point out, because Mary and I don't want to take a lot of time and want to leave you being able to ask us some closing questions, but there are other issues that really impact or are impacted by the presumption. On page 2 of the bill purports to take out partial physical custody and primary physical custody. They are removed from the bill. That's on page 2. And what that does, it creates a huge void. I assume they were taken out, and this is just an assumption, I assume they were taken out because now the assumption is that it will be shared. But as Representative Helm pointed out, and we would all agree, that's not always going to be the case. You might have someone that can actually get past the burden of proof. But we've now removed partial and primary. And so there's a huge void. We've also taken out sole legal and sole physical, and I'm not sure why, because there are rare cases. I've done this 42 years, and I probably have 3 cases where my clients have gotten sole legal, but it does happen, and in those cases it was really justified. On page 3, under types of awards, what the court is allowed to do, again, it goes back to my prior comments. You've removed primary physical custody and partial physical custody. That creates another huge void. With regard to grandparents, and I believe this was covered perhaps by Gail Calderwood as well, grandparents' cases are normally about visitation or partial custody. Visitation meaning, because we changed the meaning of it about 10 years ago, visitation now means visits in the home. Partial custody means something other than shared or whatever. Could be hours. Grandparents generally got partial. Now, partial's gone. Grandparents either get shared or supervised. That probably removes 95% of the grandparent cases that would be out there. I could go on, but there are some issues, and as Judge Clifford said, especially as chair of the Joint State Subcommittee, we really look forward to hopefully being invited to work with your committee. Nobody here thinks that shared parenting is bad. Nobody. I think I can speak maybe better than some because of all my male clients. They are my work, and I know that they want to be able to have primary. They don't want to be relegated to share when the tables are turned. I think probably 2 of your most important witnesses were the 2 before us, because they are in the trenches, and they do hear it. And I will tell you, because I do a lot of appellate work, the Superior Court has regularly, absolutely knocked down any opinion where there was not a total review of those factors. I never walk into a custody trial without having a memo which reviews the factors, because I want to remind the court they have to do that, but the court has to do it. I will take Judge Clifford's comments about, yes, maybe it's best to have it on the record or not have it on the record. I kind of go in between. I don't like the idea of saying it's only written, because there are cases in which you need an immediate decision. So I think a combination of the 2 If the court deems it appropriate to do an immediate decision, then it must be followed up by the written opinion. But even the ones that are allowed to be given on the record were supposed to be a review of the factors. But you're sitting there, you've either just won or just lost. You're not going to remember what the court said. So I would like to see a combination of, if the court deems it appropriate that there must be an immediate resolve, that there also must be a written opinion to follow. I think in closing, we want to make this work. My committee is working very hard. Mary and I chair 2 different subcommittees, and I think we have the most meetings of anybody. I have a committed group of people like Judge Clifford, like Judge Eaton, like Mary, who are on my committee working very hard to try and make our current custody statute better. So we welcome the opportunity to work with your committee. Thank you.
Do you have questions for Maria, or would you want me to just go through? Okay. So at this point in class, when I was in 4th grade, the teacher said, let's do jumping jacks. Are we a little tired of being seated? Okay. So I am here not to bring levity, but just to bring my passion. And Maria and I actually beat out the judges because we figured out we've been doing this for 82 years. And you have to tell me, do I look great? I testified 10 years ago, and I want to see that video and see if I look just as good as I did 10 years ago. And actually, it was on 50-50 custody. The custody law is evolving, and it can always get better. The concerns you raise have to be addressed, but not with this bill. This is the wrong solution. So I'm going to jump to the one thing in my materials, which is the hypotheticals of real families that I have met. And these are families like my family, a third of them are actually my family members. Is it fair to these children to say presumptive 50-50 or 60-40? Father leaves wife and 2 girls and says, I can't handle 2 kids. And oopsie, he goes, moves in with the girlfriend who's pregnant. A little hard for those children to adapt to going off to dad 50% of the time just because he couldn't handle them in mom's house. Should that evolve into 50-50? I sure hope so. It didn't for them. A mother of a teen moves in with a father of a classmate. So you've got a teenager whose mom just moved in with a classmate's father. Can that teenager handle it? No. It'll get better. But at that separation, that's not a time you can impose on that teenager 50-50 custody. And guess what? One of the things I do, which I really love, if anybody wants to come, I'd love to have you. I teach with someone else at Upper Dublin High School, and we ask the high school students to do hypotheticals on the issues of separation and divorce. It's always on custody. I have learned so much from them. And you know what teenagers want? They want their lives intact. They want to get ready for high school, for college. They want to go to their activities. Does that mean they shouldn't go to see the secondary, the partial custodial parent? Oh, they have to go. But to tell them that they've got to upset their lives and go to 50-50, not right out of the box. Parents, oh my gosh, what about our Asperger and our autism children and our special needs children where you have one parent who is the caretaker? Sometimes, for example, if you have a physically large child, it's the dad that can physically manage that child. Mom is physically not strong enough. Is that going to be automatically 50-50 until we go through that whole trial? Of course not. Really close to home, a child's fight with one parent is bringing a wedge into that family. Now, they didn't go to court. They didn't, because that wedge between mom and son led to mom and daughter lived in one house, dad and son lived in the other house, and there was a lot of respect. There was the physical proximity. It was not about the schedule. It's about respecting the fact that mom and son were really having problems. And interestingly, never got divorced, but they did their own split custody. Oh my gosh, my client's husband was sexting with her sister. She kind of didn't want her teenage girls having a lot of physical custody time with dad. She didn't even know how to explain to her kids why she was getting divorced. Cannot be presumptive 50-50. Couples are separated, limited resources. One must move home with the parent. You've got a relocation. We can't afford to be together. I have to move to Cleveland. And you're not going to have presumptive 50-50. All those pro se people never lived together. Guess when they ask for custody? So mom says, I can't get welfare unless I go to support court. You go to support court and they say, where is your custodial parent? Where's the father? Because father has to contribute to support. Father gets tapped in support court. Father says, well, if I'm paying support, if I get 40% custody, I get a discount. If I get 50-50, I get a discount. I'm going to custody court. These are the pro se people who were not living together, a lot of our constituents. Two things. My last sole legal and physical custody, it was a no-brainer. Dad was in jail because he thought he needed some money and he showed up at the bank with a gun and got arrested and put in jail. She was really nervous. Mom got primary sole legal and physical custody, so it does happen. The case that gets to my gut is not in my examples. It was a case where they had 3 sons. One son was severely ill. The other son was quite ill. The third son was just emotionally stressed out and mandated 50-50. And mom was despondent because dad had 50% custody and she had been the caretaker. And she kept coming over and bothering him and covering over and bothering him. And one day he took a chainsawed her, and fell on the chainsaw himself. Murder-suicide. Okay, I don't think 50-50 worked. We have tragedies every day in our world. Sometimes you're like, why am I going to go to work? There are parents back here who are saying, I was not listened to by the judges. I got to tell you, the best thing we have are the new judges. The judges the best thing I have is my new couples. My couples in their 30s and like coming up to 40, they got out of the box and said, we're going 50-50. We've always raised our kids 50-50. They're not going to court because they assume they're 50-50. They have that mindset. More and more of our young judges have that mindset. More and more of our judges say, hey, you know, I really kind of like shared custody. Why not? We will have bad judges. They will mess up. I go home and lose sleep because my client didn't get what they deserved. But fortunately, in my experience, 40-plus years, is that we see that less and less because we're doing the right thing. We want to work with you. We always want to improve the custody statute. Maria, do you remember we passed and we did the 16 factors? I got to tell you, those custody judges were like throwing darts at me saying, I have to itemize 16 factors. You're making my job so hard. And I'm like, oh, well, that's what you got to do. Questions?
Thank you very much for your testimony and your passion. Anybody? Representative Knowles?
Thank you, Madam Chair, and thank you, ladies, for being here. Maybe I should have asked this question earlier, but I will ask it now because I've been listening to the testimony and going through a lot of what we have in front of us. So if I missed something, Madam Chair, forgive me. My understanding, what I heard was that Kentucky is the only state with the equality in parenting law. Well,
No, sir, that was not my testimony. I
oh
apologize.
no, I'm not saying it was, but I'm just asking.
My understanding is, and I think Mr. Hale, was it?
Can I just finish?
The question. Let him finish the
Yeah.
question, Jerry.
So my question is that it's all about the kids. It's all about the kids in terms of a relationship that has gone bad. So my question is that if indeed Kentucky is the only state with the 50-50 parenting law, have we seen a decrease or an increase in incidents of physical or sexual abuse? Does anybody?
Well, we heard the statistics from Kentucky, and I think that if you want us to do research on that, we're happy to work with you. I actually quoted the psychologist from 10 years ago because I was here 10 years ago. So I think there's work to be done, and we will do it. My concern is that in those abusive relationships, the chainsaw case, that was an abusive relationship, and that dad knew his reaction was to be abusive. So in that one case, that's not the whole statistical world. If you want research on that, we will give it to you. but I don't, and I actually am on the legislative committee for the American Academy of Matrimonial Lawyers, and we've been talking about this shared custody issue over and over again. And what we try to get all our legislators to do is say, let's look at the best interest of the child, and our colleagues who worry about abuse inform us and give us the data and give us the help to give you the answers, which I can't do off the top of my head.
And I would suspect that the DV folks may be able to help us with that research if you would like us to look further into that.
Madam Chair, I think that that's very important if we can, number one, identify exactly what states currently do have the 50-50 parenting, and secondly, what, is there any data that's out there in terms of the question that I asked? So, thank you, ladies. Thank you, Madam Chair.
Thank you. Madam Chair, I'm happy to clean up my notes and share that with the committee, absolutely.
Absolutely. Any of the research, and I know that has been mentioned by a couple of the testimony, any of the research I think will go, and I know Representative Helm is always open to have a lot of conversations about, and looking to other states is a valid way. We do that with many, many public policy changes. So look forward to any information you can impart on that. Any other questions? No, I don't see any. Thank you very much for your testimony.
Thank you very much.
Before we conclude, I just want to read the submitted written testimony for the record. We have received written testimony from the Pennsylvania Psychological Association, Christian Stahl, Child USA Advocacy, Barbara Hart Justice Center, Lori Nicholson with the Parental Alienation Awareness, Richard Dolke, attorney, APLC, Melody Seebeck, Dr. Matt Lane with Fairview High School, Timothy Schilling with the Families for Civil Liberties Union, Joan Cloth Zaynard, founder of Executive Director of PASS Intervention, Bill Ayers, Pennsylvania Bikers for Justice, Pamela Lewis, Dr. Mark Rossman, William Eckenroth, Gemma Bryant, Tamara Sweeney, Stephen Berta, Shelley Thompson Okaraski, Tricia Fisher, and Lucille D. Phillips, and I apologize if I mispronounced anybody's name because none of you were Smith. But with that, thank you for everybody who participated today. Thank you for my colleagues for being here, my fellow chair, and talking about this issue. And Representative Helm, thank you for the bill, and I'm sure she is open to many conversations that you will have on the conversation. And with that, this meeting is adjourned. Thank you very much.